We'll begin today hearing from Dr. Ziliotto, who authored the guide and will present and discuss its contents and developments.
Thank you very much. Thank you very much, Livia, for introducing this event, and Joshua for coordinating this launch and the discussion afterward. I would like to express my gratitude to the discussant who took the time to read and provide feedback on this guide. It is truly an honor and a pleasure to have you here today and accepting our invitation to participate in this event. I'm thrilled to present to all of you, as well as the audience joining us by Zoom, the essential components of the guide for inclusive language in court and legal documents. This guide has been developed in collaboration with Livia Holden. The guide for an inclusive language in court and legal documents represent a significant achievement of CULTEXP, as it the primary outcome of our work on developing the first multilingual and cross-jurisdictional database on cultural expertise. The guide is designed to be a crucial part of the measures implemented by CULTEXP to promote inclusive justice. It aims to raise awareness among legal professionals and experts about the importance of using inclusive and non-discriminatory language. Additionally, it serves as a means to prevent the potential misuse of data for racial or ethnic profiling and other forms of discrimination. It is important to note that this guide does not impose mandatory guidelines, but rather offers advice, incentives, and suggestions to enhance awareness about the necessity of adopting inclusive language. The suggestions provided in the guide serve as examples that can be adapted, monitored, and updated by readers to find similar or improved solutions based on their specific context and circumstances. Moreover, this guide is intended to foster self-generative capacity for the use of inclusive language. While existing sources on inclusive language often provide prescriptive instructions and static content dictating specific terminology to use or avoid, our guide acknowledges the inherent flexibility of language. It provides tools to develop the generative knowledge required to adapt existing language to the specific context and needs in which legal professionals and experts operate. The guide aims to raise awareness and encourage readers to reflect on the use of language that is appropriate to the context and respectful of cultural diversity. It seeks to promote equality and respect for all individuals, regardless of their characteristic or background. It also acknowledges that language has the power to perpetuate discrimination, consciously or unconsciously. In contrast, inclusive language consciously avoids using words and expressions that reinforce stereotypes, prejudice, and the exclusion of certain individuals or groups. This guide for an inclusive language is structured into three main sections: focus, sources, and concept. The first section, focus, set out the objectives of the guide, identify the specific gap it aims to address, defines the target audience, and provide guidance on how to effectively use the guide. The second section, sources, offers a comprehensive and easily accessible overview, the key concept related to inclusive language, racial or ethnic profiling, race, ethnicity, and belonging. The third section, concepts, delves into various concepts and provide illustrative examples specifically related to inclusive language in court and legal documents. These examples are organized thematically and offer practical and contextualized reasoning for the use of inclusive language. The guide identified 12 micro areas. They are set in alphabetical order: age, culture and cultural concept, gender and sexual orientation, health and disabilities, institution and titles, legal citations, names, persons, political parties and movement, race, ethnicity and belonging, religious and beliefs, and status. Each micro areas begins with an introduction that outlines common challenges and offers instruction on using non-discriminatory language. And then it includes example and explanation of culturally relevant or preferable terms and concepts. The CULTEXP guide has adopted a generative knowledge approach in developing the guide, with English being the primary language of the project. However, the team's ability to speak more than 20 languages has greatly contributed to the collection of a diverse and valuable data set. The CULTEXP guide adopts a constructive approach by providing a concise collection of positive examples. The CULTEXP guide primarily focuses on European sources while broadening up toward a global perspective. It aims to provide a compact overview of various types of sources, including international law and treaties, soft law sources, secondary laws, and existing policies. The CULTEXP guide emphasized the need for an interdisciplinary approach that bridges disciplinary gaps and position the notions of race, ethnicity, and belonging for strengthening inclusive justice. The guide acknowledges that race, ethnicity, and belonging are social constructs without a biological foundation. Yet they significantly shape people's perception, decision-making process, and have implications for rights, obligation, and responsibility. In the legal context, it becomes crucial to navigate this concept in a way that avoids unconscious discrimination and the perpetuating of inequalities. The guide highlights the importance of understanding and critically engaging with these notions, considering their historical, cultural, and social dimensions. The CULTEXP guide urges legal professional and expert to be mindful of their language choices, mitigating the risk of conscious and unconscious discrimination. It promotes generative knowledge, encouraging ongoing learning and adaptation for inclusive justice. By actively considering diverse perspectives and avoiding stereotypes, inclusive language fosters a fair and accessible legal system. Many thanks for your attention.
The development of these guidelines was not possible without the comments and direction of our distinguished colleagues. As such, we'll now hear from our panelists whose invaluable input helped to shape and improve the guidelines. Right now, we'd like to welcome our first panelist, Tiki Monacoso from AfroMediaNet.
Good morning, everyone. I'm very happy and thank you very much, Livia, to give me opportunity to participate on the launch of this special guide for inclusive language at court. It's something very interesting and also important because the matter of inclusive language starts with the law itself. And sometimes we can see that even in the law, the language is not always inclusive. Regarding, for example, my experience as expert at court, I faced a case which was not a matter of discrimination, but it was a matter of use, just a word that for me was not inclusive. It was a case where a judge has to refer to my date of birth at April 1st. But the meaning he wanted to give to my date of birth was that there was apparently 20 years of difference between the experience that I was explained in the expert report and the age of the claimant. But because April 1st was, or everybody knows that is a sort of joke everywhere, I feel like he linked my expert report to a joke. So when they asked me what I think about the decision, I was a little bit confused, and I say, I'm very sorry, but there are many, many pages of my report that he may consider. Why did he go to the appendix note to reveal my date of birth in the decision? And finally, it was an amazing case because I think that it was not a matter of discriminatory, but the fact that April Fool, myself, I'm not signing any report on April Fool because, for example, in France, if you sign or you take a legal decision on April Fool, they can reject it just because they consider that the day is not a serious day, if you can consider it like that. At the same time, what was amazing is that the former Lord Chancellor and Secretary of Justice in the UK, Chris Garland, was also born April Fool. So the matter of the date of birth, which was not the age, became a serious case because I was explained that if they consider my date of birth as April Fool, they also have to think that the Secretary of State of Justice was also born April Fool. And it was an amazing case because finally, between the lawyer and the judge, they found a solution. But for me, it would have been discriminatory, but at the same time, I'm sure that the judge did not think about that day at all, but he was talking about the difference of age. So in terms of inclusive language, of course, myself as an expert, I also have a case where it was dealing with albinos, and the definition of albinism was too scientific for me. And I have to use the word, the local word that they use, which is really discriminatory in Cameroon, to show the profiling and the weight of discriminatory that the claimant face. And I explained in my expert report that I will use a local word that they call Ngengero. Of course, it was not easy for them to pronounce or to consider, but I did all the report not using the word albinism, but Ngengero, because Ngengero has a sort of heavy sense of discriminatory behind that I cannot even explain in French or in English. So when we have to deal with inclusive language, I think at some stage, of course, we have the racial profiling that we can maybe avoid, we are conscious of that, or the ethnic profile, but you also have sometimes some link or some aspect in our written or in our way of explaining things that could be interpreted as exclusive or discriminatory. And this is one of the attention that I would like to call for maybe other experts or other people dealing with code. Of course, we also have the issue of the feminine or the female or the male. In law, most of the time, the law is written in masculine, word, not necessarily thinking about she or her, but always on the he and his. And probably sometimes if they can accept to say madam or sir, they use more sir than madam in every written document at court.
Professor Anna Nordberg from Lund University in Sweden. Thank you very much, Anna.
Thank you. Thank you for inviting me to participate and to review this guide. This is very much needed work, and it's a most valid contribution to the field. And I was given 5 minutes, so I'm going to focus on 5 very quick points that I would like to highlight in here. A first point that I think is very important, and it's it comes from this guide is also the acknowledgement that language is a living instrument and it's not a static thing. And it is constructed, socially constructed through usages. Some terms that once might have been inclusive have become derogatory and vice versa. This happens. One thing remains stable, and we know that, is that language should always respect human dignity and should respect each individual and each group in their also in their inherent dignity and other human rights. So terms are important in this aspect. It's very important that we learn how to speak and write in a way that is inclusive. But it's also more important that there is an effort of thinking about these things. There is an importance of looking at the substantive content, especially when we think about other languages where having neutral pronouns might not be possible at all or very, very difficult to accomplish, unlike in English where we can do that work. The second point goes to legal language that varies but carries a linguistic but also a legal scientific element. There are specific legal terms, and those are not easy to adapt or easy to change as well because they are present in legal texts. They also might be different and connected to legal traditions and to each country as well. So a very positive point is the inclusion here of a contextual element in this guide and the acknowledgement that anything and this advice and this information has to be adapted and can be adapted to different contexts. A third point it goes about is a general point about labeling. Labeling persons is always has to be approached with great care, even if it's done with an inclusive goal. And that also is something that recognizes that persons that might meet some criteria of the community to be part of it might not necessarily be, consider themselves or identify themselves as belonging to that community. So we should also not make those assumptions in legal languages. The fourth point comes to the challenge, the great challenge of educating ourselves and promoting language inclusiveness. And in this point, the flexibility that is provided by this guide is very important. That flexibility allows to educate, to expand the idea that we need to think about constantly about inclusiveness, but also acknowledge that people that use language have different levels of language proficiency, especially when speaking a foreign language, for example. We use more and more English in our communication and English translation, and sometimes might not be easy. But also that any terms and expressions that are promoted and that they use, they are widely accepted by the relevant communities and are stable enough and clear enough because legal texts and legal decisions are going to stay for a very long time. They're going to be quoted and cited as they were. So any type of language that is used or replaced should have that also that element. The last point, and that is to us legal scholars, is that we see that, and there's already been focused. The legal texts have outdated language. They often, even human rights conventions, see that there is sexist language and other types of discriminatory content in the legal texts that are supposed to be promoting equality and non-discrimination. It's very difficult to change, to modify, and to update those legal texts. But it is possible for legal scholars and teachers to promote the use of inclusive language through contextual interpretation of this text and promote that. Of course, we have to refer to the original text as it is, but we can promote that this should be interpreted and understood in a way that is inclusive. And that was all the points that I have to make. I finish by again congratulating the authors and thanking for having me here.
We would now like to welcome our next panelist, Professor Matthias Roy from the Friedrich Alexander Universität in Erlangen-Nuremberg. Thank you very much, Professor.
I thank you, and thank you for enabling me to share some thoughts on this tremendous guide here, which we are in dire need of. I highly appreciate the equally clear and cautious approach. You don't dictate, you suggest and you explain. And I think this is extremely valuable, especially for people with a legal education. At least in my country, we know that in our universities, the faculty of law are the least diverse ones. And so you have all sorts of consequences out of that. We are indeed in need to make the rule of law experienceable in daily practice, especially for those groups and parts of our societies who are heavily discriminated against. And I think this guide is a really valuable tool for at least increasing or suggesting more awareness to this respect. According to my observations, there are not so many open prejudice or even a direct discrimination to be found in state institutions or in the judiciary, but a lot of unconscious biases. Very often, I think lawyers are a bit too self-confident about their life experience and the dimension how to explain conflicts raising within society. There is a lack of information also about access to sound cultural expertise. What we see in German courts, for example, is some kind of random choice of experts. So if a lawyer, for example, happens to have a Turkish family history, which is shown by his surname, some judges would take him to be an expert about Turkish culture, whatever that is in detail. So it might be a sign of kindness, but in fact, it's a way of racist perception of people. So indeed, we do need this sensitivity. And let me give only two current examples of my country, of Germany. This week, we had a broad public debate on so-called clan criminality, and I had to give a number of interviews on that because I'm working in this field. They don't talk about the Scottish clans, the extended family, but about extended families originating from the Middle East, coming to Germany due to political reasons during the civil war in Lebanon, especially. They were not welcomed at all in my country, and they are often living in an extended family context. But we have, for example, people who have a particular surname. We don't talk about the Smith clan, we don't talk about the Miller clan, but we talk about the R clan or other names without taking into consideration that criminal families, and we do have some highly criminal families within these extended families, they are not representative for the bearers of these surnames at all. To the contrary, the vast part of members of these families are very honest people who are living a decent life, and they are all suspect now. They suffer from discrimination because of their surname. And we have police statistics, for example, if you don't pay for public transport and you bear a certain surname, this is perceived to be clan criminality, so-called clan criminality. So So the problems, then there are existing problems, are blown up in a way which you can only call racist at the end. And another example is a recent decision of a court of appeals in Germany dealing with a dower agreement, a mahar agreement between Islamic Muslim spouses, and they declared this agreement unenforceable. And the argument was this is not compatible with a modern understanding of marriage. I mean, I am a German lawyer. I never found a modern understanding of marriage as an element of any legal provision, nor as an element of court decisions. So this is in a way a kind of open prejudice against the cultural practice. The Supreme Court has corrected that, has overruled it and said, well, it makes a lot of sense perhaps that the groom gives something as a gift to the bride, since we know that we do have still a gender pay gap. We have discrimination for gender reasons still in our societies. But I think these two examples demonstrate the dire need of this kind of suggestion of a non-discriminatory language in the law, in our institutions. And just to mention, I happen to be the spokesperson of an expert group in Germany on what you would call Islamophobia in English terminology, and we will present our report at the end of June, and it will be fully translated into English. And we took precisely this kind of examples to demonstrate the need of improvements in this field. So thank you so much for this important initiative for raising awareness here, and I would really highly appreciate to even foster our European connections and initiatives in this field. For example, the European Judicial Training Network. I'm sure you are already in close contact with them, Livia and the others. They publish a casebook now, and I just contributed my part demonstrating one of these cases. So I think if we join forces, we can even be more powerful in the sense of doing justice for everyone in society. Thank you.
Let me also join my colleagues in thanking Livia and the staff of CULTEXP for the invitation and for giving me the opportunity of reading thoroughly the guidebook, which is very, very inspiring. Also, I need to make the best use of my 5 minutes. So let me just say at the very outset that I like reading the guidelines in a twofold perspective. The first is, I would say, the proper perspective, which is to read the guidelines as addressed to a specific law-related audience. But at the same time, I think it is the second perspective is also as important. And in this case, I would like to read the guidelines as addressed to a wider general public. In fact, the guidelines are a superb outcome of the project, and I think that they deserve to circulate widely within specialized law circuits, but also in favor of a general audience interested and committed in promoting civic culture, intercultural dialogue, equal opportunities policies, and human rights at large. I say this because the context in which the guidelines are meant to be applied, that means the legal context, is very important, because language in courts and legal documents have an impact on the general context. But at the same time, the general context also has an impact on the specific legal circuit. The legal context does not live in a cultural and societal vacuum. And this is particularly important from the point of view of that very high-profile content of the guidelines, which is stressing on the self-generating capacities for the use of inclusive and non-discriminatory language. the inclusive language approach has a great potential for being addressed to a wider target audience, as indicated also in the paper at point 1.5. And I would think that in particular, in my opinion, teachers and teachers organizations, as well as trade unions and workers organizations, ought to be involved in reacting to the guide and eventually adjust their language practice to its suggestion. Now, let me follow the example of our colleague from Nuremberg and suggest in particular that it would be extremely wise to approach Equinet, which is the network of national equality bodies that are public institutions which member states are required to set up under EU law. The purpose of equality bodies is to promote equality for all, tackle discrimination, and provide assistance for victims of discrimination. The Commission of the European Union is at the moment working on a proposal to set binding rules to strengthen the role and independence of equality bodies. So I would say there would be a very important target for the outcome of the guidelines. So let me say a few things on the law-related audience. The inclusive language approach is an area of interaction between two parts of the Charter of Fundamental Rights in the European Union, namely Title III and Title VI, dealing respectively with two essential constitutional values such as equality and justice. In other words, the inclusive language approach is a component of human rights policies. Furthermore, I would like to stress that some parts of the guidelines reflect some societal pathologies that are coped with through recognition of justiciable rights. This is the situation with racial and ethnic profiling, and in all the situations in which hate crimes involve the use of hate speech. In fact, we have here a shift from hate speech to hate language, and perhaps the guidelines might underline the fact that at least in some part they deal with justiciable rights. Although extremely sophisticated, the guidelines have the potential of meeting basic challenges to all those rights that deal with human dignity at large. At some stage, hopefully an early stage, the guidelines ought to be presented to law schools, schools for the judiciary, professional bar associations, in order to receive a feedback from the main specialized audience and be eventually, to some extent, adopted. But I see three dangers, and this is not a criticism, but I would say a sort of remarks raising awareness that the guidelines may meet more or less the same criticism addressed to the or against the politically correctness attitudes. Considering also that there are possible conflicts between the legal field on the one hand and social dynamics that cannot be under any legal control on the other hand. For instance, let me raise the problem of consistency of a preference for inclusive language and protection of free speech. In the area of negationism is an example. Second, let me point out the problem of the consistency of a preference for inclusive language and protection of freedom of artistic freedom. Third, let me raise the problem of the consistency of a preference for inclusive language and protection from ideological profiling. I say this because the use of inclusive language is an indicator of a frame of mind consistent with the values implicit in the worldview represented by the Cultural Expertise project. But the reverse is also true. That means that the use of a non-inclusive language is potentially an indicator of a different set of values. In other words, the language thus becomes instrumental to a profiling of individuals and groups. And I just would like to submit such remarks to you and see if you share them and if there is any way to cope with them. Well, thank you very much for your attention.
Thank you. We are perfectly on time. So thank you very much to everybody to have followed very nicely the direction of our moderator. The discussion has been very rich, as have been also the input throughout the guide, and this let me renew my gratitude for your involvement and commitment during this endeavor. It has the potential to continue, and I hope this is a good news. Because we just got the news that our project Chi Perizia has been selected for funding by the COST. COST is a program, a European also funding. So we will start a new project with with 22 countries, many from Europe, but also extended to country outside Europe. And this is a very welcome addition to the network, because one of the findings of EuroExpert was actually that we are talking a lot about diversity in Europe, but there is a need to include in this concept of diversity also non-European input. And this is exactly what we would like to pursue with this new network funded by COST. And the aim of this project will be to fund networking activities. So it will be mainly about meeting and conferences, and one of the output will actually one of the endeavor, the action will be also the developing of this guide and the adaptation of this guide to several contexts. And this is where all your input and your contribution actually have the potential to be materialized even more. So with reflection on the use of this guide and adaptation in other languages, in other contexts, for other jurisdictions, and for a variety, to see whether we can find, and I hope we will be able to find common fields, common interest, common language, and at the same time respecting all the variety and the diversity. And perhaps responding also to the risk that Roberto was highlighting. Of course, yes, we are always confronted and with diversity of opinion, which also include opposition and non-agreement. But this is the challenge. This is the challenge that we face as project, and as a researcher who believe that inclusion is necessary and beneficial to humanity. So let me conclude with an invitation to join Chi Perizia. Everyone can join Chi Perizia. It will be published on the 9th of June, and it will be on the, we will circulate the information on the mailing list, because the beauty of Coast Action is that everyone can apply to join. After publication on the 9th of June, the application will be open on COAST webpage, and I hope that many more will join, and we will continue this work together. Thank you very much.